excuse me, Jason Thompson, Office of Revisor of Statutes. House Bill 2652 requires the clerk of the appellate courts to publish monthly a list of cases of the Supreme Court and Court of Appeals in which a decision has not been entered and filed within 6 months of submission, and also a list of cases in which a petition for review has not been granted or denied within 6 months of submission. The amendment is to KSA 20-3301, which is a statute about time limits for court decisions that was enacted back in 2014. You'll note that most of the bill is removed, or most of the current law is removed, and it's replaced with the this reporting requirement. So the clerk of the appellate court would publish a monthly list of cases of the Supreme Court and the Court of Appeals where the decision has not been entered and filed within 6 months of the date the case was submitted for decision. That term, submitted for decision, is defined in the bill, so they have some parameters of what they're looking for. And this would be posted on the court's website, and it would be also forwarded to the Judiciary committees, the Speaker, the President, and the Attorney General and the Governor. So this list would be distributed. There's also a list that would be published of cases in which a petition for review has not been granted or denied, and that would just be for the Supreme Court because they're the only ones that do that part, I think. I think that covers the basic idea of the bill. It would take effect on July 1st if adopted, and I'll answer your questions.
Okay, thank you, Jason. I just have a quick question. Everything that has been stricken with new added language, does it replace that, or are there things that completely go away?
Madam Chair, it's a great question. The parts about the district court that are stricken are not replaced, and I think the conferee can talk about why that choice was made from a policy perspective. And then the only part that is preserved is some language about how an appeal is deemed submitted that's on the bottom of page 3. And that language is kind of echoed in another place. But the rest of this would replace the current time deadlines that are in statute for the Court of Appeals and the Supreme Court. And on a side note, like, I don't want to get into it too much, but on a side note, the provisions about the Supreme Court were ruled unconstitutional in 2015, right after they were enacted. So at least as to subsection C, that's dead law in the eyes of the Supreme Court. So this would replace basically everything in the bill except that one little piece that's preserved and used as a definition, basically. So I know it's a little confusing, but just treat it as new language, I think, is the simplest thing to do.
Okay, that was very helpful. What questions do we have for the revisor? Anybody? Representative Curtis.
Thank you, Madam Chair. So I'm assuming since we have a bill that would require them to publish this monthly, that they currently do not publish that monthly, or do they?
Madam Chair, I'm not aware of any list like this that exists now. This would be a new list.
Thank you. And I imagine the proponent would then opine or provide information as to why they need this list published. Okay, thank you.
I'll defer to them. Yes, thank you.
Okay. Okay, seeing no more questions. Thank you, Jason. We appreciate that. We will go ahead and call to the podium our Solicitor General, Tony Powell. Thank you so much for being with us. We appreciate you being here in person. Mm-hmm.
Okay, can you hear me okay? All right, thank you very much. I am Anthony Powell, the Solicitor General. I do want to thank the chair for her accommodating me. I had a very important personal family matter that took me out of state yesterday and couldn't appear, so I'm very grateful to you for rescheduling and letting me appear today, and I apologize to anyone that I've inconvenienced for moving the hearing date. I know people are busy and they change their schedules, and so I appreciate it. To answer the question that the one representative had, they are not published. There is not a published list of cases that have not been decided. The courts do keep track of all this information, and I know that because I served on the Kansas Court of Appeals for 10 years, but they don't publish it, and that's why we're asking that these cases be published, the fact that a decision hasn't been rendered. This bill, as the revisor has discussed, is really simple and straightforward. It doesn't require judges to do anything. It simply, in our view, provides a measure of transparency and accountability to the process. It's really motivated by two basic things in our Constitution. Our Constitution declares that all political power is inherent in the people, and that two, in Section 18 of our Bill of Rights, it says that justice should be administered without delay. And any delay particularly lengthy delays, harm the litigants and the administration of justice. And that's the reason really for this bill. When I was on the Court of Appeals, we had an internal process whereby all the members of the court were sent after 60 days a list of opinions that had not been decided 60 days after the case had been submitted for a decision. So internally, the court, at least at the time I was there, had an internal process whereby all the judges could see a list of cases, the names, the case number, who was on the panel of cases where the decision had not been rendered within 60 days. And I think that served as a motivator for the judges to stay on top of their caseload. I think that's the responsibility of all of us as public servants to be proactive and to get our work done. But I will just tell you that my concern is that in recent years, we've seen a delay where cases where at least the solicitors that talk to me about it feel that those opinions in various cases should have been already issued. A couple of examples that I can give you. There are a number of cases that are called summary calendar cases where they're not submitted for oral argument, they're merely submitted on the briefs. Typically, those cases are relatively straightforward. Not in every case, but in most instances, that's the type of case that they are, 1 to 2 issues. And we're seeing a growing number of those types of cases where decisions haven't been issued for months. And it's just the solicitor office's view that it shouldn't take that long to get those opinions out in those particular cases. One of my solicitors has a case where it's a probation revocation case, and there's a challenge by the defendant to their probation being revoked. Well, the clock is ticking because they're now serving their sentence, and they're saying, I shouldn't be serving my sentence because my probation was wrongly revoked. Well, if the appellate courts take too long to decide that, eventually they end up serving their whole sentence and the case becomes moot, and that's a problem. And it's our hope that by publishing these cases, it'll spur, greater action on the part of the court to get these opinions out. But that's why it's important. Delay can be a problem. I will tell you too that in the Supreme Court, the problem I think has been worse. When I was on the Court of Appeals, we used to hear cases all over the country and all over the state, and lawyers would talk to us and they would say, gosh, we appreciate how fast the Court of Appeals gets its opinions out. I've got a case in the Supreme Court and we've been waiting 2 years for an opinion. We used to hear from lawyers who used to tell me that all the time. And so I think lawyers would appreciate, I think if you ask them privately, they would tell you that they would appreciate the effort that we're trying to do here.
And I know it's shocking how fast 2 minutes goes.
Oh, did I have a time? I'm sorry, I took too much time, okay.
No, that's okay. Go ahead and give us a high point and
I think that you've pretty much heard the high points of the bill, so I'll be happy to stand for questions.
Okay, that's great. We will go ahead and ask the committee if you have any questions for our Solicitor General. Representative Curtis.
Oh, thank you, Madam Chair. So by publishing this list, you think that then judges will perhaps move their dockets a little quicker? Is that what you're thinking?
That's the hope. It motivated me. I never wanted to be on the 60-day list. And during my 10 years on the Court of Appeals, I think I had less than a dozen cases, and I wrote over roughly 800 opinions on the court. I was on the 60-day list less than a dozen times. So, because I just felt like when I had one of my cases got on that list, I didn't want my college to think that I wasn't carrying my end of the load, as it were. Now, sometimes there are cases that were complex, and they took longer than 60 days to try to figure out. And so it's one of the reasons why we're not violating the separations of powers here. We're not telling judges what they have to do. We're not telling them that they have to get their opinions done earlier. It recognizes the fact that there are cases that take longer because they require more effort, they're more significant. But in general, I think it's our view that the appellate courts could do better, and we're hoping this will help.
Thank you.
Representative Martinez.
Thank you, Madam Chair. Thank you for your testimony. You may have kind of answered this, but why do you think these delays are occurring? You said the past few years that it's become,
I really don't. I know that the caseload of the Court of Appeals is going up really from COVID. That's part of the issue. Other than that, I'm really not sure why that is. Back in, when I was first on the court, we had heavy dockets where there would be 30 cases on a single docket. So each judge had to write 10 opinions a month. Their dockets are not that heavy currently, yet it seems like we're seeing more delays from the court. So I don't really have a good answer. Maybe the court, representatives of the court can give you an answer to that, but I'm not really sure why that would be.
thank you.
Representative Carmichael.
Thank you, Madam Chair. Good afternoon, Judge. During the briefing of the bill by our revisor, he did mention that a number of the strikes that are contained in the bill were as a result, I guess, of a Supreme Court decision. My guess is I know the grounds, but could you educate me as to what occurred and what their...
Separation of powers. The legislature can't, in essence, tell judges how to do their jobs, and there were provisions, previous enacted provisions by the legislature to say you had to render a decision within 180 days, and if that didn't happen, lawyers and their clients would have certain remedies.
Right.
That was a separation of powers problem. So we avoid all of that by simply saying we're not going to tell the judges what to do, but here's a list of cases, and you haven't got the work done, so the people can at least see what kind of case it is, and hasn't been decided.
And I agree with everything you've just said. I understand why we need to try to speed things up. Thank you.
Okay, committee, do we have any other questions? Okay, seeing none, I think we're done. Thank you for your service to our state. We really appreciate what you've done
Very much.
in your
Thank
career.
you very much for
Mhm.
accommodating me.
Yes. Okay, committee, I don't think we have any written testimony, neutrals, or opponents to House Bill 2652, and so I will close the hearing on House Bill 2652. And I'll open the hearing on House Bill 2747, and we will get a brief from Jason. Thank you, Jason.
Thank you again, Madam Chair. Jason Thompson, Office of Revisor of Statutes. 2747, we're going into a different area here. We're back in the criminal code. The bill is specifying that courts shall consider certain factors in determining whether a prior violation of law is comparable to any act described in certain driving under the influence crimes when calculating a person's criminal history score under our Sentencing Guidelines Act. So the amendment is in 216811, which is the criminal code statute about calculating criminal history classification. And the current law, and there are some special rules in here, essentially. You hear the commission and others talk about special rules. These are some of those. Basically, that certain prior adult convictions or juvenile adjudications for driving under the influence and similar laws are scored as felonies for criminal history purposes. So even if they were a misdemeanor or a adjudication or anything like that, they're scored as a felony for criminal history purposes. And that is for certain crimes of conviction that are specified in the bill. Some of those are involuntary manslaughter while DUI, aggravated battery by DUI, and another one is leaving the scene of certain vehicle accidents that cause injury or death. And so your prior DUI-related convictions can count in your criminal history as felonies for those specific cases that you're currently charged with. And the bill essentially adds a provision from the DUI statute. It's copied from 8-1567 subsection J that says when you're determining whether something is comparable, there's a special test. You look at the name of the jurisdiction offense, the elements of the offense, and whether it prohibits similar conduct. And I won't get into the details too much. I know you've got District Attorney Bennett or someone like that lined up to kind of get into the nitty-gritty of how this works in the real world and why this new provision is needed here and not just in the DUI statute. But essentially, you've got differing case law. You have case law under the DUI statute that says This test works, and you can count Wichita DUIs from a certain time period that may have included bicycles, for example, or you can count out-of-state DUIs that are similar, even though they're not identical. But then you get into the special sentencing rule, and that rule is different, and you can't count those same DUIs for these special sentencing purposes. So that's kind of the nuts and bolts, I guess, behind why you're asked to add it here. The one place wasn't good enough, and there are some consequences in sentencing that you'll hear about from other folks as well. So that hopefully gives you a background on it. And I do know that this would take effect on publication of the register. That's not typical of criminal bills, so I wanted to point that out. This would take effect as soon as you would pass it, and it would be published in the register rather than July 1st. So happy to answer questions if I can. I know you've got good testimony coming up too, so.
Okay, thank you. We have a question from Representative Carmichael.
Thank you, and if I talk quick, maybe I can make it 2. As I understand it, under this bill, there are people who will have pled or been convicted of misdemeanors, but at the time of sentencing on a subsequent offense, those misdemeanors can be considered as if they had been felonies for purposes of sentencing?
Madam Chair and Representative, let me clarify because
Sure.
we're close. We're close.
Okay.
So there are currently 3 rules in this statute that are amended in this bill. And they all say currently that your prior adjudications or convictions of certain DUI-related crimes count as felonies. That's the current law. They've been doing this, I don't remember for how long, but for a while. But there are certain DUIs that because of how the jurisdiction defined the crime, they're not similar enough to meet the test of this statute, even though they would be similar enough under the DUI statute to be counted as prior DUIs if you were charged with just that crime. And the crimes here, your current crime of conviction has to be involuntary manslaughter by DUI, aggravated battery by DUI, or leaving the scene causing injury or death. I think those are roughly the 3 areas where this special rule regarding your prior conduct and treating them as felonies applies. So it's a pretty narrow grouping of current offenses that use this prior offense against
With your
you.
leave, Madam Chair, I'll be quick.
Go ahead.
So would this have retroactive effect? In other words, 3 years ago, I pled guilty to one of these misdemeanor offenses, and now I'm up in 2026. Would we go back and apply this new law and deem what I thought I was pleading to be a felony, even though it was a misdemeanor, a felony for sentencing, even though it was a misdemeanor? At the time I said I'm guilty of this misdemeanor, now it's going to be used against me as a felony. Do we reach back, or does it start with publication in the register?
Madam Chair, Representative, so the direct answer to your question is no, it should not be retroactive. There's no language in here indicating that it is. Generally speaking, criminal sentencing statutes cannot operate retroactively. It's difficult to make them do that without violating the Constitution. But on the more general level, these, regardless of your plea, if these are in your record, when you come back for one of these other crimes that has a special rule, they are counted as felonies in your criminal history. So that's already happening and will continue to happen. It's just that certain DUIs that may not be counted under current law, which you're about to hear about some of those, if that charge was made after this bill was in effect, you would count more of the DUIs than you do right now, if that makes sense. But it is not retroactive, to answer your direct question.
Okay, committee, any other questions for the revisor? Okay, thank you. All right, we'll call our first proponent on WebEx. We have District Attorney Mark Bennett from Sedgwick County. Is he there? Okay. And I don't know if you heard, we're trying to keep our testimony to about 2 minutes. You can do that? Are you there?
I am. Can you hear me? Can you hear me okay?
Yes, we can hear you.
Very good. All right. So
Yep, thanks. Welcome to committee, I think for the
Thank
first
you.
time this year.
I think it may be. Thank you very much, Chairwoman Humphreys and other members of the House Judiciary. So briefly, the situation is this. If somebody picks up a DUI, we look back to see is it their first, second, or third, or subsequent. And we have for a very long time said that prior DUI convictions count to enhance the sentence of a DUI. So the Your first one is a Class B, second one's a Class A, third one becomes a felony. And we look back and determine what the nature of that prior was. There was an issue with a couple of different priors. So the city of Wichita, for a period of time, for reasons that I could not explain in 2 minutes, included things, DUIs that occurred on bicycles and other things. And so that created an issue. We also have DUIs from other states who may define their own DUI laws in whatever fashion they do. And so there's been a great deal of case law that's set forth in our written testimony here that explains how the courts have worked that out. Now, add to that the fact that we have a sentencing guidelines grid. And so if you have only misdemeanors in your past, all you've done is committed 5 or 6 DUIs, and you go commit a aggravated robbery, you'll be sentenced as an H in the guidelines because you only have misdemeanor priors. The legislature years ago made a decision that if you commit a vehicular homicide or an involuntary manslaughter while you are drunk, while you are DUI, then your prior DUI should count. The idea being that the thing you have done in the past that is so similar to what you're doing now should count against you. So if I go and am drunk tonight and kill somebody in a car wreck and it's an involuntary manslaughter while DUI, and I have no history, I'm sentenced as if I have no history. But if I have 2 DUIs, it's not just as if I have misdemeanors, it's that I've done the same exact behavior and I finally killed somebody. And our legislature years ago said that should enhance. That the issue that came up here in the case that gives rise to this, and actually there's several of them, but one's highlighted here is Deputy Carter, who was killed by an individual who had priors from Arizona and from the city of Wichita that did not count because of this issue with the bicycle, the way the law was written. So what we're getting at here is, had he been convicted of DUI, this individual, if he'd been convicted of DUI in the district court in my office, he would have been sentenced as if those 2 prior DUIs were felonies. And his sentence would have been enhanced because it was DUI, and he finally killed someone while DUI. Because he was convicted in the city of these priors, they don't count. And so he's sentenced to a much reduced sentence. And so what this proposed change is doing is simply saying that the law as it's written now should apply to anyone with a prior DUI. And there's again, in 2 minutes it's hard to get at this, but there's a litany of cases that have been decided by our appellate courts, which carved out an exception. And today we're simply asking to eliminate that exception, and that anyone convicted of a DUI in their past who goes out and kills somebody, really hurts somebody, a DUI while aggravated battery while DUI, or flees from the scene of a situation like this, that those prior DUIs will count and enhance their penalty. It doesn't apply to, pulling a gun on somebody. I mean, it's simply limited to DUIs enhancing the penalty for new DUIs that hurt, kill somebody, or that you flee the scene. So that is highly summarized, but I know I'm limited on time, so I wanted to stop.
Okay, and you can stay for questions, I'm assuming, if anyone has a question. Okay, thank you so much.
Thank you.
I'll now we have here in the room, Jerry Carter. So if you could come on up, the DA referenced Deputy Carter. So this is Deputy Carter's dad, and we really appreciate you coming and appreciate the work that you've done to get this in front of us. So the time is yours.
Thank you, Madam Chair, and members of the committee. My name is Jerry Carter. I am the father of Deputy Sidney Carter of the Sedgwick County Sheriff's Office. Sidney was killed in the line of duty October 7th in a horrific vehicular crash, which changed our family's life forever. Sidney was only 22 at the time of her death. She worked for the Sedgwick County Sheriff's Office for 15 months in the jail, then was recruited for the road enforcement. After she completed the road academy and her road training, it was her 6th day out by herself when she received a disturbance call. She was heading to the call when another driver failed to stop at a stop sign and hit Sidney's patrol vehicle on the driver's side door. The driver of the other vehicle was driving 85 miles an hour in a posted 55 miles per hour zone when he hit Sydney's patrol vehicle, killing her instantly. Sydney was just starting her career. She always wanted to help others. She had aspirations of becoming a U.S. Marshal. Sid was only 4'11", but that never stopped her from doing anything. When she was younger, she was in gymnastics and dance. She loved drawing and art, which she did for her quiet time. We all have a lot of pictures she painted and pictures she drew. Sydney did dance for many years, even after high school. Then she went back to assist her instructor with the younger girls while she was working for the sheriff's department. Sydney had lots of friends. She left impressions with everyone she met. Sydney seemed to become friends with the kids that were quiet, shy, withdrawn, and didn't seem to fit in. The loss of Sydney hasn't just affected our family, it also left a very large hole in the hearts of her friends, co-workers, and the law enforcement community. The offender was tested and found to be under the influence of marijuana. The night he was interviewed by an officer, he told the officer he was heading home. When the officer asked what street he was on, he said 53rd Street North. Vehicular crash happened about 5 miles south of where he ran the stop sign at 29th Street North and 135th Street West. He also informed the officer that he smokes marijuana every day. And that night, he had just left his friend's house where he smoked a blunt, and as a reminder, this was not his first DUI. Our family was informed at the first meeting with District Attorney Mark Bennett and Deputy District Attorney Aaron Breitenbach that this offender had 2 prior DUI charges in the city of Wichita. One was charged in 2013 and another in 2015. We were also told that these two DUIs could not be used because of the Wichita law. Wichita law took sentencing down from just shy of 15 years to 3.5, which I myself do not comprehend. This was his 3rd DUI offense and killed our daughter. However, due to the Wichita law sentencing, we could only use the 3rd DUI. This is not right in my mind, and this is why we wanted this reform to be fixed. So no other family has to go through the frustration that we went through. The frustration of knowing for 3 years, going through the court proceedings, that the offender's prior DUIs could not be used. Please pass House Bill number 2747 so other families can receive justice that we did not have the opportunity to. And I know there is no justice that can bring back Sydney to us, but this could help other families get the justice they deserve. Sydney is truly loved and missed. And with that, I'll stand for questions at the appropriate time.
Okay, thank you, Mr. Carter. We'll let you know if anyone has any questions. Okay, next we have Jeff Easter, Sedgwick County, from Sedgwick County, and he's representing the Kansas Sheriff's Association on WebEx. Sheriff Easter, are you there?
I am. Can you hear me?
You sure can, and there you are. We can see you. Okay,
Okay,
thank you.
well, thank you,
Give it 2 minutes or so.
Chairwoman Humphreys and committee members for allowing me to testify on behalf of the Kansas Sheriff's Association. Mr. Carter has laid out exactly what occurred. And the fact of the matter is that, you know, the sheriff's office, the Carter family, and the community itself suffered a tragic loss on that day on October 7th, 2022. I think Mr. Bennett has laid out exactly what the law is calling for. I will tell you, What we were shocked about as well was that those two DUIs, prior DUI convictions, could not be used. And then on top of that sentence not being able to be imposed, the suspect in this case was violated on his bond for felling a UA for more drugs in his system. And he spent the next 19 months in our jail awaiting his trial and sentencing. At the time of sentencing, he was given credit for that 19 months, plus the automatic 15% good time credit through KDOC. So this gentleman who killed Deputy Carter is going to do less than 30 months in jail, which is just unconscionable to us. The irony of this case is if he would have gotten those two DUIs in Sedgwick County, and a Sedgwick County deputy would have given or arrested him for those DUIs, and he was convicted in Sedgwick County District Court, we wouldn't be here today, more than likely, because he would have received the longer sentence. So we're simply asking for this committee to look at this particular bill as it's written and pass out of committee for a floor vote that hopefully no other family, such as Mr. Carter and his family, has gone through. So with that, I will stand for any questions.
Okay, thank you. So committee, what questions do you have for any of our three proponents? Representative Carmichael.
Thank you, Madam Chair. My sincere condolences to Mr. Carter and the members of Sedgwick County Sheriff's Office. It's a tragedy and one that I think of with some frequency. My question is for District Attorney Bennett, and it relates to the Wichita City Ordinance. And I know this bill is broader, but the Wichita City Ordinance, it had some provisions about bicycles, and I remember them, and I know some of the characters involved, but let's don't go through it here today. But irrespective of this bill, has the city of Wichita fixed those ordinances now so that they match the state statute, or is there still an incongruity between the two?
My understanding, John, is that the Representative Carmichael's has been fixed, and so the issue then is more just the historical prior conviction. So, but to answer your direct question, I believe it's been fixed.
And Mark, Mr. District Attorney, we're on the same page. Thank you.
Very good.
Committee, do
Thank
we
you.
have any other questions for any other proponents? Okay, seeing none, we don't have any written proponents, any neutrals or opponents. And so I'll close the hearing on House Bill 2747, but we really appreciate you coming, Mr. Carter. And I think that I hope we can do some good for your family, for others, so they don't have to suffer the same thing. Yep. Thank you for being here. Okay, so I'll close the hearing on 2747, and we will open the hearing on 2651 and get a bill brief from Jason.
Thank you again, Madam Chair. Jason Thompson, Office of Revisor of Statutes. Shifting gears yet again, this bill will take you over into the Family Law Code, specifically a statute under the Kansas Parentage Act. So what this bill does is authorize a challenge to a voluntary acknowledgement of paternity at any time after acknowledgement in cases of fraud, duress, or mistake of fact. And it also specifies that genetic testing results are considered a material mistake of fact for the purposes of those challenges. As I mentioned, the statute amended, excuse me, 23-2204 as part of the Kansas Parentage Act found in the Family Law Code. The bill adds to current law that the father of a child born to an unmarried mother may complete an acknowledgement of paternity that shall include the consent of such mother and the written descriptions required by subsection B. That's basically current law, but it's spelled out very explicitly in the new subsection A language you see there. Subsection B is then amended to reflect some other changes in the bill, because subsection B is basically what the state registrar of vital statistics puts on the form that folks are asked to sign, typically in the hospital. And so subsection B changes are just kind of to make it consistent with the other changes, so you know what your responsibilities and rights are when you sign one of these acknowledgements. The new subsection F is where we begin the changes in the bill that I wanted to mention real quick. The subsection F is really a restatement of law that acknowledgement of paternity creates a permanent father and child relationship without the requirement of further adjudication. So signing this does create a right and responsibility. It is, of course, though, subject to challenge. And so that's where new subsection G refines some of the current law about challenges. It provides that it preserves the current law that you have 60 days after signing or prior to the date of any administrative or judicial proceeding relating to the child to establish a support order. So you have a time limit to challenge right after signing, a maximum of 60 days or prior to the date of an adjudication, whichever one is earlier. So 60 days max. The new subsection G2 talks about what happens after that deadline. And that's where the real peanut of the bill probably is. You're allowed to challenge based on fraud, duress, material mistake of fact. But then for purposes of this section, we're specifically stating that a genetic test is a material mistake of fact that can support your challenge. And also extending the time for you to make this challenge. Under current law, it's fairly limited. And I think that's part of what you'll hear about. And the last thing I will say about subsection G is that it is retroactive to the extent that it can be. It's stated in there that it should be construed and applied retroactively. So that is deliberately done in the bill. And then finally, there's this, never mind, I don't even need to talk about subsection H. That's basically current law. So I'll just leave it at subsection G. That's the real peanut of the issue, allowing these challenges based on fraud, duress, material mistake of fact, and basically opening that up to a longer period of time, and also providing that specific note about genetic testing being a material mistake of fact. So happy to answer questions if I can. I know we've got testimony too, so.
Okay, thank you. Committee, do you have questions for the reviser about this bill? Okay, seeing none, we'll go ahead and hear first from Representative Tom Kessler, also from Wichita. Welcome to committee. Thank you for bringing this to our attention.
Thank you, Madam Chair, committee. Actually, you did a great job explaining the bill, and actually I have a couple other people that kind of tell their story, so I'm going to just try to be quick here. We made some of these changes. Anyways, pretty hard to imagine actually what some of these guys have gone through, and I've actually had several people reach out to me, not just 2 people in Kansas. I've had several people reach out, but we've made some changes to this VAP. Basically, the first step that we made was we wanted to make sure, because we don't have a clear definition about genetic testing as far as being a material mistake of fact. So we made that clear in there that can be a material mistake of fact. The other part is the retroactivity part of this. So I wanted to make sure we could go back and pick up people that have fallen into this trap versus just from today forward. There might be some complications to that, but I want to be clear. The intent of this isn't for none of the people that I've spoken with care about. They thought maybe the possibility of people suing the state to get money back once they're found out they're not the father. I just want to be clear, that's not what we're asking for. So they just want the people that are falling into this trap just want this to stop, just want it to end. And then none of them are looking for retribution or to be compensated. So I want to be clear about the intent of that. So those are kind of the 2 big parts of this. And with that, I'll just rather let you hear their stories because they're pretty impactful. You're going to say to yourself like, damn, does that really happen? Because it does. So I'll be happy to answer questions at the appropriate time.
Okay, thank you for being here. Okay, we will now have Chasen Sewell, private citizen, come up. Welcome to our committee, Chasen. Thank you for being here.
Thank you for having me, Madam. And
Yep, and you push the button on the microphone to make sure that it's on. Is it on? Okay, great, thank you.
so I'm here today in support of the bill. So long story short, since we have 2 minutes, I was 18, 19 years old at the time, and I was with my fiance, and she ended up getting pregnant. We had been together for a few years at that point, so I did what I needed to do, took care of her during her pregnancy. Everything was fine. We went to the hospital when she was ready to give labor. Kid was born healthy. They brought some paperwork out, birth certificate, voluntary acknowledgement of paternity. I signed them without even reading them, had no idea what it was. They brought it out right in front of the mom. The kid had just came. Obviously, I didn't want to I didn't really look into it. So signed them, continued to raise the child. She didn't work. I was the sole income. I was in school full-time as well at the time. When the kid was about 15 months old, and that 15 months number is very important. I came home from school to a man running out of the back door of my home. So at that point in time, I went and got a DNA test on the child and found out the child was not mine through biological DNA testing. It was rough. I mean, it was a really, really rough time of my life. So essentially afterwards, I did continue to try to be in the child's life, but I was forced out by the mother and the biological father because they went and got a DNA test on the guy that she was having an affair with. Turned out that the guy that was running down my back door was the father of the child. So they decided that they wanted to now parent this kid, and they didn't want me involved with the kid anymore. This was devastating. I mean, I can't even begin to explain to you guys how the emotions I went through this. I mean, it was terrible. But at this point in time, I went and saw an attorney, and the attorney basically advised me after taking $500 that I had no rights in any of this because I wasn't the biological father. And so at this time, I pretty much cut the mom and the child off, and I stopped seeing them entirely. So we're going to fast forward 3 years. You know, that 3 years was tough. I went to therapy. I tried to make it through all of it. I'm with my wife now. We're 1 week out from our wedding. I receive a child support subpoena in the mail. And I kind of was like, man, here it comes again. But I thought, no big deal, because I have the DNA test of mine, and I also have a copy of the DNA test of the biological father. I figured I'd be able to present that to a judge, and that would be the end of it. So I go to the Sedgwick County courts. I schedule all the stuff I need to schedule. I get seen in front of a hearing officer. I present all the evidence myself without an attorney, and the hearing officer basically tells me that I'm out of luck, and she can't do anything for me because I signed what's called a voluntary acknowledgement of paternity. The voluntary acknowledgement of paternity gives you 12 months after you sign it, after the child is born, and to revoke it. I didn't find out the kid wasn't mine until 15 months old, and this was 4 years afterwards because it's just when I got the letter in the mail. So she told me that I needed to try to find an attorney, and she wished me the best of luck. At that point in time, I went and found an attorney, put a $5,000 retainer down. The attorney, he's filing motions, all this. I'm getting thousands of dollars of bills every month in the mail from this attorney, and all to pretty much lose everything. The judge ruled against us every step of the way. She wouldn't go, nothing went my way with this. At the very end, I got put on child support. I'm under a child support order right now, all for a child that's not mine. I have no biological relation to the kid. Haven't seen the kid in 4 years. The kid doesn't know who I am. The kid's actual biological father is in the kid's life, but he's not going to go step up and try to fight it because he knows that he's going to be facing child support. So I feel like this whole deal, it's really just enabling deadbeat fathers is what it is. And then that's not what I am. I have a son now. It's the joy of my life. I'm not a deadbeat father trying to get out from child support. I just want to move on with my life from a horrible situation. But the state of Kansas and DCF are just harassing me with this, I feel. So.
Okay, and you can stay in case anyone has a question for you.
Be happy to answer.
Thank you for telling your story and for bringing this. We appreciate it. Okay, we now will have Garrett Tillery come up. Thanks for being here, Garrett.
Well, thank you. I'm just going to read straight from the testimony. Easier to explain that way. My name is Garrett Tillery. When I was 17 years old, I was informed I was the father of Daniel DeShazer, born on April 1st, 2017, and was assured that no one else could be the father. Trusting this information and wanting to do the right thing, I signed the birth certificate. 6 months later, a mutual acquaintance informed me that I may in fact not be Daniel's biological father. I took the steps of obtaining a notarized DNA test from UCI Testing in Wichita on October 6, 2017. The results confirmed that Daniel wasn't my son. I shared these results with Daniel's mother, Haley DeShazer, and I had no contact with her or the child since October of 2017. Around that time, Haley had made a Facebook post acknowledging that Daniel's father was a man named Philip. Despite these facts, I was summoned to Kingman County Courthouse on November 20th of 2024 to address the child support claim filed by DCF on behalf of Daniel DeShazer. I attended the hearing without legal representation, presented the court with the notarized DNA test results. The child support claim would have exceeded my monthly rent. During the hearing, the DCF attorney stated the department's intent to continue pursuing child support from me. The presiding judge told me it sounds like I need a lawyer. I spent a small fortune to retain legal counsel, My lawyer and DCF had multiple back and forth communications where they demanded I pay child support. Reasons I do not understand, DCF ultimately did not oppose a motion by my lawyer to dismiss the child support claim against me. However, my lawyer told me due to Kansas statutes, I cannot remove my name from the birth certificate, putting me at risk for another claim. Here today, thanking you for an attempt to address this issue for me and what is likely hundreds of other Kansans in the same situation. Thank you for your consideration on this important matter.
Okay, thank you, Garrett. We appreciate it. Committee, we have those three proponents. Let's see if you have any questions for any other proponents. Representative Carmichael.
Thank you, Madam Chair. My question is for Mr. Is it Sowell? Now, step up for just a moment and push the button so we can hear you when you answer. Excellent. I see in your written testimony, you say that your only remaining legal option is appeal to the Court of Appeals, which requires posting a $132,000 bond to appeal a child support case under Kansas law. Go on to say, I don't have the financial means to post such bond. I can't practice law here. I'm retired. I'm a legislator, but I'm not sure that posting of bond is a prerequisite to pursuing an appeal. It is a prerequisite to stopping execution on a judgment. Do you know anything at all about that?
So all I know is that in order to appeal my child support hearing, the court essentially requires you to have all the child support for the remaining of the sanction or whatever. So for 14 years, essentially, because the kid's 4 years old, I would have to have 14 years of child support up front, and I just put it into a bond account through a bond company. That costs money in itself. And that's so, from what I understand, it's so if you lose, you don't just flee the country and not pay your child support. That's the way I understood it. But yes, it was, the number for me was $132,000 I would have to have up front in order to appeal it.
Madam Chair, I know our revisor has a lot of work, but I'd appreciate if someone in the revisor's office could take a look at that appeals statute and see if people do have to post a bond in this circumstance.
Okay.
I don't think it'd be done today.
Right now, or maybe
But someone.
research, I don't know, one or the
research,
other. Y'all can
right.
talk about it. Okay, thank you.
Thank you, ma'am.
Any other questions? For any other proponents? Representative Bohai.
Thank you, Madam Chair. Representative Kessler, please. Thank you so much for bringing this to our attention, because I didn't know that this was going on. I am assuming there are more than just two gentlemen that we will be potentially helping with, in the heat of the moment, signing an acknowledgement that then later becomes handcuffs, essentially. Does this bill fix that? Does it actually fix it? Like, or will people still be signing these voluntary paternity acknowledgements and then have to go to court? Like, are we going to fix the problem, or are we making it so the problem can be solved with extra steps?
Madam Chair, Representative. So, yes, it kind of fixes that, right? So what it does is it takes those hard dates of where you can't file after a year anymore. I mean, it just takes it away. I mean, there's no exception about that. It kind of removes that exception, allows you to file at any time once you met one of those three definitions. So, I want to be very clear here. I mean, we made it very front and center on this, and we actually even highlighted it, that the judge has to take the child's best interest first. We're not asking to put adult's interest above the child. We maintain that. We want that in there. So every case is different, every circumstance is different, but we want the judge to be able to continue to do that. So we want to put the child's interest up first. But yeah, so we do address that by eliminating those hard dates.
Representative Vaughn.
Thank you, Mr. Chair. And I think this would also be for you, Representative. So just kind of alluding to your the statement that you made about potential maybe consequences is too strong of a word, but just, I think the on the flip side of this, if we do unlimited retroactivity, I think that there could be potentially rippling effects on the mothers or the state, potentially having to, repay support potential lawsuits, things like that. And I mean, it sounds like that would be appropriate in some of these cases. But I'm just wondering, was it ever discussed instead of complete retroactivity, if, would it be appropriate to put some kind of time period? And would you have any suggestions about what that might be? If I'm putting you on the spot, I understand.
Madam Chair, Representative, so might be a great question for the revisor. We did put a date in there. There was a date that was added, and that was, I believe that what that had to do is that's when we initiated the VAP, right? So when we added the VAP to the bill, it kind of went into this date. So you have to figure, I mean, it's not going to go back more than 18 years, right? I mean, that's the window that we're looking at, the first 18 years of the child's life. So, and if you've been involved in that child's life any length of time, and the judge determines that it's in the child's best interest that you stay in that child's life for whatever that looks like, or be responsible, then that's up to the judge. We don't take that away. But yeah, we kind of, I mean, it's an 18-year window as it is right now. So does that answer the question? I'm not sure.
Yes, kind of. I do, or I'm hearing some murmurings from my colleagues. I wonder if we could double check that. I think 18 years sounds appropriate to me. I just want to make sure that that is the way the law would act under this.
I'm not, Madam Chair, I'm not so sure that child support is going to be after 18 years old. That's why I say that.
Okay. Okay. Thank you.
Jason, is there anything you want to add, or?
Thank you, Madam Chair. Jason Thompson, Revisor's Office. So I would, the date that the representative was referring to is on page 2, talking about an old provision that was in the bill prior to July 1, 1994. There were certain acknowledgments that had to be dealt with. So we had to update those effective dates to be that date, not this current bill, right? This was in place way back then. So you see that odd July 1, 1994 in there. But the retroactivity provision on page 3 in line 28 and 29 is just open. There are a few ways you could address that. You could limit the retroactivity to, actions or cases based on occurrences prior to some date. It's a little hard to narrow it down with a year. Another suggestion was to limit the challenge period with whatever you wanted to do as a retroactive period. So if the challenge could only be brought, 5 years after discovery, I picked a random number, that would essentially limit the retroactivity also to 5 years, right? Just because of the nature of the section itself. So there are a few ways we could get at it if we wanted to explore that.
Thank you. Thank you, Madam Chair.
Okay, committee, any other questions?
Might I inquire
Yes.
the revisor on that same?
Representative Carmichael and then Representative Goddard.
Thank you, I appreciate it. When child support is due and payable and owed prior to majority, in other words, before the age of 18, my recollection is that it can still be collected even after the child reaches majority, perhaps subject to some statute of limitations, but I think it's a judgment. I hope you understand where I'm at on this.
Madam Chair and Representative Carmichael, yes, I think I understand. Yes, if it's been entered as a judgment, for example, DCF, took over the case and you owe a judgment under Title IV, whichever letter it is, I can't remember right now, that can continue even after the child reaches majority. So if that's the circumstance.
And I'm not sure we're even setting aside prior judgments here, or are we?
Madam Chair, I might wait for the DCF representative if they're going
Oh,
to
I thought they were
testify.
neutral. Okay, never mind. If they're testifying, great. Thank you. I
Maybe
apologize.
they'll have the answer to that.
My only hesitation was, I know that when you get in child support enforcement, there's a big difference between when the state is trying to collect it and when an individual is trying to collect it. But in any case, to your broader point, it can, I think, continue past the age of majority if it's been awarded and is considered a judgment, et cetera. So.
Okay, Representative Goddard.
Thank you, Madam Chair. And my question is for Mr. Sowell. Could you go over the situation when you signed the VAP and let us know again how that occurred?
So I'm going to be honest, it's a little bit of a blur because just everything, and it was a long time ago. But from what I remember, the kid was born and they brought, I remember signing the birth certificate. I honestly don't remember signing the voluntary acknowledgement of paternity, but that's when they bring it out, I guess, is when they bring a birth certificate out. So the kid's born and they bring it out and they just have you sign it. They didn't explain anything to me. I wasn't explained that this was, I was signing away my rights, essentially, is what I was doing. Nothing like that was explained to me at all.
So during a very emotional time, somebody shoved some papers at you and you sign. And now, as I understand it, you could protest that VAP for certain periods of time, but after a year, it's a moot point. You can't protest it anymore, and you are locked in.
Yes, you're locked in so tight that I actually had 4 local family law attorneys to Wichita turn me down. Like, I had to search for an attorney to take on my case because they all said that it's an unwinnable case. That's how locked down you are in it after 1 year. And I didn't find out till 15 months. So I, at no point, even if I would have filed it the day I got the DNA test, I would have been in the same boat.
So you were in the child's life for a period of time,
15 months.
but then shut out from the child and the mother, and no contact, but you're still on the hook.
Yes, she received food stamps for 3 months, and that's what got this all started, actually. So I guess I don't know if I put that in my testimony. She didn't file child support against me. It was the state of Kansas that did that. And in fact, it's in my testimony. The mother has stood up in court and said she doesn't want me involved financially. She doesn't want me in the kid's life. She doesn't want anything from me. She said that in court in front of the judge, and it just doesn't matter because the law is the law, essentially.
Okay. Well, thank you. This is a bad situation as far as I'm concerned, and thank you for your testimony, and thank you, Madam Chair.
Okay, Representative Osmond, question?
Thank you, Madam Chair. With your leave, just 2 quick questions to the revisor. Question 1, so under the bill itself, it says a genetic test that identifies another man as the father shall be construed or considered as a material mistake of fact. If the genetic test is just you are not the father, does that rise to the level of fraud, duress, or material mistake of fact?
Chair, Representative, if the test says you are not the father, then yes, because the fact was you were the father and that was a material mistake, then I think so, yeah.
Okay.
I don't think it has to identify who the father is, just that you were mistaken in the fact that you were the father is the idea.
Okay.
That is a material mistake of fact, which would then trigger the ability to file a claim, the best interest analysis by the court, et cetera, et cetera.
Fair enough. Thank you very much for that clarification. Second question is, assuming that they are successful in their determination, is the judgment then just a clean break moving forward, or is there any retroactivity upon the mother as far as previously paid child support payments?
Madam Chair and Representative, I'm going to lean on, as an example, today where we've hopped from subject to subject three times now, and a fourth coming up. I'm a generalist and I just don't know the answer. The support issue is complicated, and I'm hoping that you've got a conferee that can help with that a little bit.
Okay, committee, seeing no more questions for the proponents, we'll now call up our neutral testimony from the Department of Children and Families, Marcelin Martinez. Welcome to committee, and two minutes or so.
Is this already on? Okay. Can't really tell. I have submitted, oh, sorry, Madam Chair. Marcelin Martinez, I'm the Director for Child Support Services for DCF, and I appreciate the opportunity to provide our testimony on the House Bill 2651. I have submitted the written testimony, and many of the things that we've raised have already been addressed here, so I know you are pressed on time, so I can just open up for questions or if there's something specific. I did want to point out, though, if this bill does move forward, one thing that was not submitted in my testimony that probably does need to also be addressed is KSA 232209. which also has the 1-year time limitation included in the language.
Okay, I'll start. So why are you neutral and not a proponent of the bill?
For some of the reasons that we've raised, have been raised here today, there is some question on the retroactivity as to whether the state or a mother would be required to repay some of the child support if the actions are raised now. Some of the cases that we've dealt with, I am familiar with Mr. Tillery's case. They are egregious situations that our hands are tied with as well. So we are not opposed to it, but there are just some questions. The genetic testing as a mandatory mistake of fact in the language is a concern. It says that it shall be considered a material mistake of fact. So I think that's implied if there's a best interest hearing, that you can use that genetic testing if you've gone through the best interest hearing and then have the genetic test available. So rather than having it spelled out as an automatic shall be in the language. I don't know if that makes sense.
Okay. I think we have another question, Representative Bohai.
Thank you very much, Madam Chair. Thanks for coming today. My question is this. You just referenced that you knew of one case. How many cases do you know of?
I'm just familiar with that one. I'm sorry.
You're only familiar with one case of the genetic problem? Like you only know of one?
Madam Chair, Representative, I am familiar with Mr. Tillery's case because I was involved in handling that complaint. I'm sure there are others because as has been discussed here today, this paper is put in front of people in the hospital during an emotional time.
Could DCF get us a number of how many this is?
No, I wouldn't have any way to do that.
Okay.
Okay, any other questions? Committee for our neutral testimony. Okay, I would make sure you please take a look at her testimony. There's a lot of information in here. I think it will be helpful for you all to take a look at it.
Sure.
Okay, thank you so much. We appreciate it. We don't have any opponent testimony, and no written only. And so I'll close the hearing on House Bill 2651. Appreciate you all for being here. And now we will go ahead and open the hearing on House Bill 2609. And we will have our very busy, hardworking, appreciated reviser give us a bill brief.
Thank you, Madam Chair. Jason Thompson, Office of Reviser of Statutes. Last time for the day, hopefully. House Bill 2609 is familiar to some of you, new to others, so I'll try to hit a couple high points. And we've got a lot of testimony. This bill would enact the Supported Decision-Making Agreements Act to provide a statutory framework for allowing an adult to receive decision-making assistance from one or more other adults, establish requirements for decision-making agreements, and also ascribe some duties related to those agreements. The bill is 9 new sections, and that is why the bill brief is 4 pages. There's a lot in here. As I mentioned, this idea has been around a few times. You have in your testimony that the 2023 bill was sent to the Judicial Council for a study. You have a full Judicial Council report. This bill reflects everything that came out of that Judicial Council recommendation. I don't believe the council itself recommended the bill. It was requested here on behalf of someone else, but you do have a full report to review, and I did my best to draft the bill in accordance with what the council suggested and recommended. So that's what you have in this new version. I'll highlight just kind of where things are and try to get out of the way for the conferees. Section 1 is just the name of the act. Section 2 is where your definitions are. So if you want to know about decision or affairs and what kind of things can be in the agreement, look to Section 2 and those definitions. I'll highlight 2 of them that are used a lot in what I'm about to say. Principal, that's the adult who enters into the decision-making agreement to receive assistance. So that's the principal. And then the supporter is the adult who enters into the agreement to provide the assistance. So the principal and the supporter are the words used throughout this act. Section 3 then talks about how an adult can enter into one of these supported decision-making agreements and get decision-making assistance with their affairs from one or more other adults. That section has how you enter into those agreements and who is not allowed to enter into those agreements. For example, if they have a protective order against them, you can't be a supporter of someone if there's a protective order against you from that person. Section 4 then talks about all the duties and obligations of the principal and the supporter. So you can look there to the scope of assistance, what can be in the agreement, who has to sign things, et cetera. So Section 4, and then even into Section 5, where the agreement has to be dated and in writing, it has to satisfy the requirements of the Act. So those requirements are in kind of Section 4 and then Section 5. Section 6 talks about the effective date of the agreement and revocation of the agreement, which can happen at any time. So it has some mechanics for the timing and the effectiveness of the agreement. Section 7 talks about the supporter owing a fiduciary duty to act in accordance with the agreement. So this is a fiduciary relationship that is established, and that carries a meaning in the law. Except as limited by the agreement, there's a list of decisions and affairs that can be managed under the agreement, and that is in Section 7. Section 8 then talks about other persons, so third parties recognizing decisions or requests from folks who have a decision-making agreement and protecting them if they act in good faith. So that's where you would look if you're concerned about third-party, say a financial institution, accepting actions that are done under one of these agreements. And there's quite a bit of new language in there, I think, from the financial institution. So if that was a concern before or still, I would look to Section 8. Section 9 then talks about an adult who enters into one of these agreements may still act without the assistance of the supporter. So they are not bound to lean on the supporter for this assistance. And it does not constitute evidence that the principal does not have capacity. Those are some new provisions that were also added to make clear that this is a voluntary agreement. It doesn't take away rights from the principal. They can still act without the assistance of the supporter if they choose to. And then Section 10 amends the crime of mistreatment of a dependent adult. This has been in every version of the bill I think I've ever drafted for it. It just adds that violation of one of these agreements or of the Decision-Making Agreements Act, and doing that in a way that leads to taking someone's personal property or financial resources, that does count as mistreatment of a dependent adult or an elder person. And so you could be prosecuted for that action and punished based on the amount of loss to the person, essentially. I think that covers it. It would take effect July 1st if you adopt it, and I'd be happy to answer questions if I can.
Okay, thank you. Committee, do you have any questions for the revisor, Representative Carmichael?
Thank you, Madam Chair. Mr. Thompson, in your briefing, I think I heard you say that you incorporated the recommendations of the Judicial Council in this draft of the bill, and I think all of them, as far as I understand. In Mr. Molina's testimony, he reminds us, though, that the Judicial Council didn't reach a recommendation one way or another as to whether or not we needed assisted decision-making. Is that consistent with your memory when you worked through the report and advised the council, as I assume you did?
Madam Chair, Representative, thankfully I didn't have to advise the council. I only have to advise all of you. So yeah, yes, my recollection of the report when I was using it to draft was that the committee made a recommendation for how to enact the bill if the policy was to allow these agreements in Kansas and create this statutory framework. But the committee was split, to be fair, I think, about whether it was necessary or not, given the new Guardianship and Conservatorship Act that was just enacted last year. And so the council itself did not make a recommendation about this is not a Judicial Council bill, I suppose is the best way to put it. And that is my recollection, that this was just a report issued by a committee. And they did good work, and it made my drafting a lot easier.
Very good.
And I did incorporate everything that they suggested as far as I know. At least I tried.
Thank you for the valuable clarification. Thank you, Madam Chair.
Okay, any other questions? Okay, thank you, Jason. we'll have our proponents come up. I just wanted to add one little thing, saying this is one of those situations where we heard this bill last year, but we've also heard it in years previous in the Judiciary Committee. I heard it when I was on Fed and State several years ago. So it's come back, and I'm very pleased that this time, because last year especially, the KBA and the bankers, both KBAs, the bankers and the bar, opposed the bill, and they came together and came up with some solutions. So please feel free to listen, ask questions and all those things, but I think it's helpful to get everyone in the room and come up with solutions, which I feel like we did to some degree for this. So everyone see what you think this time. Okay, we have 7 proponents. We're going to do 2 minutes each-ish, but if you are less than that, then you can yield your time to other people. So, we certainly will allow for you to do that. First, we'll have Mike Burgess from the Disability Rights Center of Kansas. Welcome, Mike.
Thank you, Madam Chair. And as she said, I'm Mike Burgess with the Disability Rights Center of Kansas, and I will attempt to be as brief as possible. Since a number of you are familiar with this before. So one key thing, I think just the easiest way to start, if you look at my testimony, I've attached a sample form from the state of Virginia. And I think it's best as you're describing this, because we can talk about this as a theoretical thing. When you actually look at the form, it's plain language, it's organized around major life domains. You can see what somebody who needs some assistance, they can easily check what they want help with, what they don't want help with, and it's very straightforward. I've also attached a sample durable power of attorney form too, so you can see and compare and contrast. And there's a need for both of these, and they're meant to complement each other. If you look at the first page of that supported decision-making form, it has a box where you can check these other advanced directives, power of attorney, and the other legal documents that work, so you can kind of hopefully get a picture of how they work together with this. Key difference with these is the individual retains that decision-making authority. They're not appointing a surrogate decision maker, and that's typically the scenario with the power of attorney. So a few things, I'm very pleased, and the Judicial Council Advisory Committee, they were very thorough, went line by line through the whole bill. They were charged with making recommendations, and I was very pleased with the way the letter requested them to do that, because they did great work. And I'm happy that all of those are incorporated in here, and we were able to address some of the concerns of the previous opponents. Since we last met, 4 states have, additional states have adopted this, so now a majority of states have supported decision-making agreement laws, plus DC. The recently passed guardianship statute also references the supported decision-making as a concept, so this bill will actually work together with that new guardianship bill. But I can tell you one thing, as I travel the state and talk to self-advocates, the number one issue of all the different things and all the committees and issues that I work on, the number one that they always ask me about is this one. And so this is very important to self-advocates. You can tell here in the room, I'm happy that they will be here to tell you themselves how important this is to them. I'm trying to think, and if one thing just to address, I know that in the Kansas Judicial Council's report, as I was looking at their testimony, they recommended a change in the implementation date. If the committee decides to do that, we're okay with that. I think having the form isn't necessarily dependent upon the effective date, because people can use, if it meets the requirement without a form, it would still meet. But if you choose to delay it, we're okay with that too. I just want to see this work at the end of the day and help self-advocates who need some help to have a tool to be able to do that with the benefits that having it in law would provide. And the revisor did a great job of explaining those protections to supporters, protections to businesses who honor or don't honor in good faith, enhanced criminal penalties for bad actors, and then the recognition that a law provides to help get the word out on this. So thank you, Madam Chair. I'd be happy to stand for questions at the appropriate time.
Okay, thank you. We'll ask questions at the end of the proponents. Okay, now we have Colin Olenek, self-advocate. Welcome to committee, Colin.
Thank you. Thanks. All right. Can you all hear me?
You sure can.
Cool. All right. So as Mike has said, and as you know from years past, the Self-Advocate Coalition of Kansas fully supports this act, and the recommendations of the Judicial Council and Bankers and Bar Association, both of the state of Kansas. Basically, it would help me maintain my independence and decision-making abilities. It would respect my rights as a person and not have to have me rely on guardianship or more restrictive interventions. It would allow me to decide what I wanted to do in my own life, and I will stand for questions at the appropriate time.
Okay, Colin, thank you so much for being with us. We appreciate it. Someone else will get an extra minute if they need it. So thank you. Okay, Laura Gaffney is next on our list. I believe you're a medical doctor. Welcome to committee.
I'm Dr. Laura Gaffney. Thank you, Madam Chair. I am also the co-chair of the Healthcare Equity Coalition with KCDD. And I'm a physician. I'm board certified in both internal medicine and pediatrics, and I've been in practice almost 30 years. For Bill 2609, you can see my submitted talking points. But Bill 2609 allows an individual to have autonomy with responsibility, and supported decision-making improves patient safety by clearly establishing consent and information sharing while improving patient engagement and medical outcomes. It allows families and individuals who may not require a guardian to improve communication in the healthcare setting. And as a physician who has seen over 10,000 different individuals with special needs, I can attest that this legislation will be helpful in allowing medical care not to be perfect, but to be perfect for that individual. And I'll stand for questions at the appropriate time.
Okay, thank you so much for being with us. Okay, next we have Ricky Hernandez, Kansas Council on Developmental Disabilities. Ricky, welcome to our committee. Can, move the microphone a little bit. Yeah, great. Thank you.
Thank you.
Welcome.
About that, my notes fell. Must have felt pretty hard because I got knocked out of cyberspace.
It's okay. Everything's fine.
Thank you.
Yeah, that's great.
Good afternoon, everybody. Chairman Humphreys and members of the committee. My name is Ricky Hernandez, formerly Ricardo Hernandez, and I am council member for the Kansas Council on Developmental Disabilities. I'm also a person with cerebral palsy, and I appreciate the opportunity to submit testimony in support of the HB 2609, the Supported Decision-Making Agreement Act. As a person with a disability, I know firsthand what it means to need support while still wanting to make my own decisions. Like many people with disabilities, I do not need someone to take over my life or make decisions for me. I need trusted people to help me understand information, talk through the options, and communicate my choices. Supported decision-making reflects on how many of us already live our lives and recognizes that needing support does not mean giving up our rights. HB 2609 is important because it creates a clear legal option for adults with disabilities to receive decision-making assistance while remaining in control of their own lives. It offers a less restrictive alternative to guardianship, and it reinforces the idea that adults with disabilities are capable of making decisions when given appropriate support. The bill centers dignity, independence, and self-determination while also including safeguards. The bill is especially meaningful to me because the committee hearing for the HB 2609 is taking place as the same day as KCDD's annual day at the Capitol. When self-advocates from across Kansas came across together to share their stories and advocate for policies that impact the lives of other people with disabilities and their families. HB 2609 directly reflects what many self-advocates are asking for, which is the right to be supported for the decision-making process. Today, I would like to strongly urge the committee to support HB 2609 to help ensure that Kansas with disabilities have access to supported decision-making as a safe, respectful alternative to guardianship. Thank you all very much for your time and consideration. I now stand for questions.
Okay, thank you. I think I'm going to see if the committee has any questions for you. We normally wait till the proponents, but it might be easier since you're settled in there if anyone has a question for Ricky. I do have a question. Do you have someone in mind already? Like who might be your helpful principal, or sorry, not principal, was it supporter? Or is that something that you would think about later?
You know, that's something I would like to take time to consider. But I come from a very strong family, and we have like a lot of great support and a lot of different options, which is a blessing. So like, if I had to choose somebody for me as of right now, due to their understanding of how I operate and my goals, and also to their understanding of the system, I would choose my sister because she just graduated from law school at UMKC.
Okay, that's wonderful. Thank you. I appreciate that. In committee, any other questions for Ricky? Okay, thank you for being here with us. We appreciate it. Okay, next we have Amy Campbell from the Kansas Mental Health Coalition. Welcome to our committee, Amy.
Thank you, Madam Chair. And I just want to thank you so much for your work in collaborating with the Judicial Council and helping them to understand what your requests were and getting that information that helped improve this bill. I was very impressed with how that interaction worked. I work with the Kansas Mental Health Coalition. We're a roundtable organization. My testimony looks like this. It's pretty self-explanatory, but we've been testifying for this bill for a long time. Would like to point out that the House of Representatives did pass this legislation 6 years ago. And since then, we've been kind of struggling at the committee level. But it was good to have these improvements. I would point out that there are 32 states that have supported decision-making as legal documents in their states. 25 of them just clarify those as legally valid documents. Why does that matter? Because that creates protections for the individual with that advisor, with that supporter, right? It sets out the expectations and the roles, and it makes it clear whose job is what, and that the principal makes the decisions for themselves. In addition, there are additional states that now actually require that alternatives to guardianship, such as supported decision-making, must be tried before a guardianship order is declared. This bill does not go that far. We're simply looking for the option. With that, Madam Chair, I'd like to let other people have time. I'd like you to hear from the people who this bill actually affects, but we do think this is very important legislation. Thank you.
Thank you so much for being with us. Now we'll have Lori Barnes come, private citizen. Lori, nice to see you. Welcome to our committee.
Thank you for having me, Chair Humphreys and members of the committee. Give me an opportunity to speak. Again, my name is Lori Barnes. I am here to express my strong support for decision-making. It's a simple idea with a powerful impact. It allows individuals to keep their rights while receiving help understanding information, weighing options, communicate decisions, and for Kansans, this is exactly the level of support they need, nothing more, nothing less. Too often our system pushes people towards guardianship and other agreements, even when the individual is fully capable of making decisions with appropriate support. Supportive decision-making offers a less restrictive alternative. The individual remains the final decision maker. I as a supporter would have no legal authority to act on their behalf. I would basically help explain information through choices, ensure that people's voice is heard. I'd be like a co-pilot, right? I'm present and helpful, but I'm not in control. There are clear and practical benefits. It can reduce unnecessary guardianships, which can be costly for families and burdensome from courts. It provides clarity for schools, healthcare providers, and financial institutions by offering a recognized framework for involving supporters while still honoring the individual's legal rights. This issue is deeply personal to me. As a parent of an adult son, Daniel, he lived with mental illness. He died by suicide July 2021 at the age of 21. When he had his episodes every 6 months, this could have been something that would have helped us. He could have remained in control of his decisions while I could have been part of his support team. I could help him understand options, information, community's choices. If this option had existed in practice, just not in theory, my family's journey could maybe have turned out differently. When you research the new guardianship law, as a caregiver or somebody, it references supported decision-making repeatedly. To me, this signifies, signals a shift. The state wants supported decision-making to be used as and seen as a real, usable alternative, just not a concept in a statute. The bill provides clarity and protections needed to make the this option meaningful. It did pass 6 years ago on the floor, and for these reasons, I urge you to pass it. In my written testimony, I have examples given of what it would be like for a supporter to go in with the principal to visit with the doctor and how things would work. So I will stand for questions and appreciate the opportunity to speak today.
Yeah, thank you for coming. We appreciate it. Okay, and then last in person, we have Stephanie Coleman. Welcome to our committee, Stephanie.
Chair Humphreys and members of the committee, I just want you to know right now you are all practicing supported decision-making by listening to all of us who have thoughts about this bill and are assisting you in making the decision whether to move it forward or not. So I appreciate you listening. With that said, my name is Stephanie Coleman. I urge you to read my full testimony. It's unique. It's sharing my son, Matthew John, and my story about guardianship. It was a guardianship he never needed. We were pushed into guardianship by misinformation from his high school on how I would not be receiving information or being able to attend his IEP meeting if I didn't have guardianship. I spent thousands of dollars as a single mother that I didn't have attaining that guardianship. And if my son had just been offered to sign a release of information, that would have solved all of this. Matthew and I have practiced supported decision-making from a very young age because I believe people should be able to make decisions for themselves. We did this from choosing the green t-shirt or the red collared shirt, and he always chose the green t-shirt because he hates to have a collar on his neck. I just didn't know that what we were doing was called supported decision-making. The more I learned about guardianship years later, I learned that it was not appropriate for Matthew and could prove harmful in the future after I'm gone. Being the mom I am, I started talking to others and learned how hard it would be to remove guardianship I received a few years prior by saying my son was incapable of making decisions for himself. It made me sick. It still makes me sick to think about this. That I put my son in a situation and now it was going to be extremely hard to undo. Fast forward a few years, Matthew went away to college and found his support while also using the text a friend option with me, his friends from home, and his Mimi. With that in mind, in 2023, I petitioned the court to remove the unnecessary guardianship. Thankfully, the judge stated he was inclined to agree with me and ordered the guardianship to be dissolved, and now Matthew is his own person. Please know, I'm not against all guardianship. I do believe that in some cases, it's really important that people have guardians. So I'm not against guardianship, but I do believe that people should have the opportunity to say, hey, I want to make decisions for myself. Please don't put me in guardianship. And people aren't listening to that right now. I tell families all the time, I work with doctors and they come to me and say, can you talk to this family? I don't believe guardianship is appropriate. And I talk to these families and I tell them, just give supported decision-making a chance. You can always go back in 2 or 3 years and say, you know what, this just didn't work. Here's the reasons why it didn't work, and we want to go after guardianship. And that's what I think. So that's my 2 cents, and I hope you take it for what it's worth. And I will stand for questions whenever you have them.
Okay, wonderful. Thank you so much for being here. Okay, committee, what questions do you have for any of the proponents? Representative Carmichael.
Mrs. Coleman, don't get too comfortable. Well, I'm glad I made an impression, for better or worse.
Yes, yes.
But I have read your testimony as you requested.
Thank you.
And I'm concerned about the events that I see described in paragraph 2. Okay? Junior year in high school, is that when your son reached majority, or?
He was 17 and he would be 18 his senior year.
Okay. And what school district was it that told you that you had to have a guardianship?
Shawnee Mission.
Oh my. I now understand the problem, Madam Chair. Thank you.
Can I?
Please,
one
with the
thing
chair's
about
leave.
Misinformation. In Kansas, we have an special education, and I'm not here to talk about funding, so don't, but special education, if you look and see, most, there's a, I forget what they call it, but regular ed teachers are doing special education. They're not trained to do special education. They don't know everything. And so they're providing misinformation. And so I don't feel like, I'm not really mad at them, but I'm also thinking, okay, superintendents, all these school boards, like if they're going to have special education in their schools, then they should learn how to best support those kiddos and individuals and families.
Certainly agree. Thank you, Madam Chair. Thank you, ma'am.
Okay, committee, any other questions that you have? I have a question. Oh, sorry, I didn't. Okay, no, you go ahead. Representative Osmond. Go ahead.
Thank you, Madam Chair. Question for Mr. Burgess. Thank you for bringing this forward. I want to admit, I haven't had the chance to read through all the testimony, especially the neutral testimony, just yet. And I'm planning to. I know that this bill has been brought forth multiple times, and we've had, and last time around, there was a lot of opposition. The opposition, I think, tended to come in the realm of, if there are multiple support decision makers, who is the ultimate one that prevails, and how does that actually get rectified when that needs to be done? If I'm understanding correctly, how has that been rectified, or what changes have you made to modify this over the last year?
Well, so I'm gonna, the report, the Judicial Council report covers all of their recommendations. I mean, and they literally walked line by line and were very thorough. As far as the specific question, I mean, the simple answer is it's the principal. They can have multiple supporters, but it's the principal who is the one that should be listened to at the end of the day. I mean, they're the one, they have capacity, they're receiving support and, from their supporters, but it's their decision. And they have every right to totally ignore and disagree with all of their supporters at the end of the day. I mean, that's their right.
Okay, you might just stay. My question is, the need for this. I mean, a lot of people, of course, have informal helpers and decision, in helping in supported decisions. But the need for this has to do when there's some sort of document that needs to go to a school or go to the bank or go to the, what's the biggest need behind this bill?
So it comes down to, I mean, it provides, again, as I kind of briefly, and it's hard when you're talking really fast in 2 minutes, but protections for the supporters, protections for businesses and institutions that honor or don't honor this in good faith, enhanced penalties for bad actors. And that I think is an important piece, because I think, we know individuals who have more self-determination are less likely to be subject to abuse, neglect, and exploitation. And then the third piece, as Ms. Coleman talked about with the schools and having a recognized alternative to guardianship, because without this statute, what was discussed, that far too often, there are folks giving bad advice with good intentions to explain about guardianship without talking about any alternatives to guardianship.
Okay, thank you, Representative Goddard.
Thank you, Madam Chair. This is kind of like an overhead comment or question, and whoever wants to address it, please do. But it seems to me that, supported decision-making is a really neat thing. And there must, in many cases, there's got to be a point where it doesn't appear that supportive decision-making is working anymore. And I'm maybe in the dementia cases or those kinds of things. Are supporters trained in when to recognize when it's no longer appropriate to continue with supportive decision-making and that maybe a guardian needs to be appointed?
I'm Dr. Gaffney. I liked your reference about the dementia, because certainly this is something I also combat. I mean, I see people of all ages from birth to 108. I have a case right now of a family, a person who has no guardian. She had been mentally capable, now has Alzheimer's, and has been catfished and had some money stolen and things like this, and her family is trying to get guardianship. So we have to go through a long process for that. There is neuropsychological testing. There has to be, for instance, her bank has required, see primary care, have to have a sign off by them. They have to have a neurology. They have to have neuropsychological testing. I think there also can be, sadly, times when people are a danger to themselves. I think there's pros and cons. I will tell you sadly that probably 75% of the people I see that come from a group home setting, their guardian never comes to their visit. Their guardian doesn't answer my phone calls. Their supported person ends up being the group home, the day service, the CDDO, something like this. I have another lovely person who, her father died, her mother had died, no guardianship. Lovely person, but could be vulnerable, okay? Her aunt by marriage stepped in and said, I'm gonna be here. She's come to every visit for 3 years. This would be a great place for that aunt to be the designated support without having to go to guardianship, because that takes money. The person doesn't have money. And so you have some people who are lingering in this area where they don't have someone they have an advocate, but they also, who's going to take on the financial burden? Who's going to agree to be guardian? Then who's going to be guardian after the aunt dies? Where they can say, I've got a family friend, and they can do that. But then, I like the fact that there's also penalties, because I have also seen people where their supporter is also their abuser. And I think that the bill also talks about that. Like, we're gonna have your support, but we're also gonna watch. And if someone makes a report that there may be some abuse, that is important. Did that answer your question?
Thank you. I think it does. And going to your last comment, Mr. Burgess mentioned that there are bad actors out there, and there are penalties involved with that. And it doesn't matter what field you're working in, there's always going to be the potential for a bad actor. And it's just a matter of trying to ferret out the bad actors and take care of it. I thank you for all being here. I appreciate what you're doing. Thank you very much. Thank you, Madam Chair.
Welcome. Okay, committee, I think we'll stop there. We appreciate everyone being here. I will go ahead and close the hearing on House Bill 2609. Just a tiny bit of housekeeping for us. We need to be on the floor in about 11 minutes, I think. Just so you know, tomorrow we have 3 bill hearings. We also will work bills tomorrow. For your information, 2 bills that we passed out of the committee are being returned to our committee to work on a little more. The Cora bill and also the bill that had to do with landlord-tenant evictions. So those 2 bills are being sent back, so that's even a little more extra work for us. But we'll get done everything we can tomorrow, just so you know about that. Representative Vaughn, question?
Yes, thank you, Madam Chair. Are there any other bills we should plan to work tomorrow?
Yeah, I'll text you and let you know, or I'll text, we'll get that out to you for sure, what might happen. And then also just want to recognize Representative Riley, who's in the audience. He's been very involved and he has introduced several of these bills through the year. So thank you for being here and helping in this situation with the supported decision-making. Okay, anything else for the good? Yes, and thank Representative Howe for being here, stepping in for our vice chair who was taking care of her husband today. So, okay, thank you so much, everybody. See you on the floor.